Good afternoon, everyone. Hi, my name is Rocky Guzman. But before we start this session, I'd like to hand over to Colleen for a video of the Seeds of Justice. Then we can start. Thank you very much. Good afternoon, everyone in Southeast Asia. Good morning and good evening to everyone who are tuned in across the globe in today's webinar. Welcome and hello from Manila. To those who have been following ARIA webinars, my name is Rocky Guzman from the Asian Research Institute for Environmental Law, or ARIEL. And I'm honored to be today's moderator for the session on air pollution in Southeast Asia, national updates, where we focus on initiatives and programs in particular countries in the region. As a background, this is actually our second webinar on air pollution, following through from the first event in June, which focused on solutions and practices at a regional scale. A lot of things have happened since then, foremost of which include the Human Rights Council's recognition of the right to a clean and sustainable environment as a fundamental human right. And closer to home, a lot of developments in environmental litigation, which include air pollution cases. For context, in the region, It's estimated that up to 250,000 premature deaths could be attributed to the worsening air quality here, making it a major environmental health risk. It also causes disproportionate impacts on the already marginalized sectors of our society, including the poor, the elderly, and children. As a result, the magnitude of air pollution, as evidenced and as we can see in many cities across the region, has impinged upon the broader human rights to life and a sustainable and healthy environment. With that backdrop, I'm really excited to hear more about the recent developments on air pollution on this topic in the region, and to listen to initiatives and programs being undertaken nationally to help solve the issue. But before we start, thank you very much for joining us. We have around more than 100 participants already, and we'd like to start by expressing our gratitude to our partners who have made this event possible. Our supporters, including the UN Environment Program, or UNEP, Clean Air Asia, LAWASIA, and EarthRights International. We also thank our esteemed panelists for today's session for their time and expertise. After this panel session, we will have a Q&A with them. But you can put your questions in the question box below in your screens at any time. We will put also a link for attendance and a link for the assessment in the chat box, so you can check that out if you are interested. Please be informed that we are also live at our Facebook page in Ariel, and you can check this video out even after this session ends. So with that, and without further ado, let's start with the panel. We are honored to have our first panelist with us, Alan Meso. Alan is a legal officer from the UNEP, joining in from their headquarters in Nairobi. Alan is an advocate of the High Court of Kenya and holds Bachelor's of Laws degree, a Master's in Environmental Law, and a Master in Business Administration. He has been instrumental in UNEP's work on environmental crimes, judicial education, environmental rule of law, and the development of chemicals in waste law. He was also part of the UNEP teams that drafted various model environmental laws, training modules, and guidance documents. And notably, he was part of the team who coordinated the drafting of the UNEP's first global assessment on air pollution legislation. So Alan, we are honored to have you. Thank you very much, and over to you.
Thank you very much, Rocky, for that extremely flattering introduction. For once, you almost confused me there. I thought you were introducing somebody else, but thanks, and it's indeed a pleasure to join you this morning or afternoon from wherever you are. Here in Nairobi, it's morning, and indeed it's a pleasure to present on what we're referring to as the first global assessment of air pollution legislation that was conducted in 2020 and was published earlier this year. So what is the basis of the global assessment of air pollution legislation? Now, the assessment was conducted in response to the United Nations Environment Assembly resolutions. Two of these. One was in during the first United Nations Environment Assembly, and the second one was during the third United Nations Environment Assembly. Now, the assessment was also conducted pursuant to the United Nations Environment Programme's Air Quality Programme, which seeks to ensure that by the year 2030, a majority of the world's population actually live in areas with the acceptable air quality standards. Now, the resolutions specifically were calling upon member states to take actions to reduce all forms of air pollution and also to set ambitious outdoor air quality standards. Now, to achieve this, that is to reduce all forms of air pollution and to achieve this acceptable outdoor air quality standards. We can only do this if we have effective laws and regulations. And therefore, on that basis, we conducted an assessment of the legislations worldwide to actually find out, are they capable of guaranteeing or ensuring these acceptable ambient air quality standards. So what is this assessment actually about? Now, the assessment itself assessed laws in 194 countries and the European Union, that is 194 countries plus the EU. And it was conducted against what we are calling an air quality governance model or framework that was developed taking into account the World Health Organization interim targets and air quality guidelines. As I said initially, the assessment was conducted in the year 2020, and it focused on national legal structures for one, introducing and implementing air quality standards. But at the same time, we recognized that science evolves with time, and therefore a scientific case for setting these standards is bound to change over time. And so the assessment looked at two major parameters. The first one is the national law capable of meeting what we are referring to as acceptable air quality standards. And two, if these measures exist, do these measures provide for consequences for failure to either achieve or observe these standards? But at the same time, we want to point out at this point that the assessment did not address whether the standards are actually met in practice. So what were the key findings of the assessment? Now, there are several, but for the sake of this webinar, I'll highlight these key ones. And at the end of the presentation, I'll be sharing with most of you a link where you can actually read the report with this assessment. Now, the assessment found that a majority of countries actually provide constitutional legal requirements that provide for legally mandated acceptable air quality. So in this case, you'd find that a number of countries would contain a constitutional provision, including the right to a clean, healthy, safety, or sustainable environment, which in most cases then would underpin the right to a clean air. Secondly, you find that quite a number of countries, which was 43%, do not define what air pollution actually is. And as we progress with the discussions going forward, you realize that this is a serious omission in terms of enforcement, because if you do not define what air pollution constitutes, then when it comes to enforcement, you actually faced with a challenge. The third key finding that you may wish to take note of is on the number of countries that have embedded ambient air quality standards in their legislation. And in this case, the percentage is a bit impressive, because we notice that a majority of countries globally, and we're talking about 64% of the countries, have actually embedded ambient air quality standards in their legislation. The next major key findings is that in as much as the majority of these countries have embedded ambient air quality standards in their legislation, you find that these ambient air quality standards are not aligned with the World Health Organization air quality guidelines in terms of their numerical standard. So for instance, if for particulate matter, an interim numerical standard is provided under the WHO, then some countries would not even make mention of what is a prescribed threshold in terms of the concentration of this pollutant. Then in a number of countries, you find that the responsibility for either implementing or enforcing ambient air quality standards, even when these are legally provided or provided in the legislation, it's relatively weak, and which actually undermines the efforts towards realizing clean air for the population. You also find that while outdoor air quality is monitored in most countries or in many countries, in about 37% of these countries, there is no legal requirement to monitor outdoor air quality. Again, without an express provision to monitor air quality, in this case, outdoor air quality, then you find that you do not have data that could actually help to either strengthen or advance your policies on air quality. Which is, again, a weakness in a number of laws that were assessed in this particular study. Another key point to note was that public participation and other procedural rights, for instance, the right to access information relating to air quality, were relatively strong globally, which is a good point, especially taking into account the resolution by the Human Rights Council a few weeks ago on the right to a clean and healthy environment. So the fact that this particular provisions on public participation and procedural rights to the environment is relatively strong, then we have an opportunity to advance in terms of public interest litigation and other mechanisms to actually strengthen air quality governance and access to clean air. Another matter of concern was actually on transboundary air pollution. Now, in this case, very few countries have legal mechanisms for managing or addressing transboundary air pollution. Now, remember, air management or managing the quality of air is not limited to a national jurisdiction. And so in the event that we do not make any effort to harmonize our efforts, then the efforts in one country might be futile because of the failure in a neighboring country. So again, perhaps there is a case to strengthen the regional mechanisms for addressing transboundary air pollution so that you can harmonize, one, the standards and the mechanisms for ensuring that transboundary air pollution is reduced, and that the citizens within a particular region, and in this case, I'll be looking at Southeast Asia, actually have an opportunity to enjoy what we aspire to have, clean air. Another element that would require some further study is indoor air quality. Remember, this study mainly focused on outdoor air quality. Now, what we realize is that indoor air quality standards are rarely included in air quality legislation in most countries. And so we found that only 7% of countries have some form of general indoor air quality standard. So perhaps this is another area that we need to conduct more study, especially in developing countries where sources of energy for domestic use, say cooking and lighting, would actually constitute a pathway for air pollution. So again, this is another area we'd want to focus on so that we can understand then what are the mechanisms out there that could help to address indoor air pollution, and especially in the developing countries. So in a nutshell then, with this study, what are the recommendations? The recommendations would be as follows. Number one, that there is need to adopt air quality guidelines in our laws as prescribed by the WHO, because that would be the normative organization that sets what parameters would be suitable for human health. Now, the latest WHO guidelines, again, the 2020-2021 guidelines, again, if you have to amend your legislation or your regulatory framework, you need to try as much as possible to align them with the World Health Organization air quality guidelines. Number two, the legislation should actually, among others, have a strong public health and environmental objective, because environment and health are intertwined. So whenever you actually are looking at an objective of your legislation, try as much as possible to have public health as a clear objective and environment as a clear objective in your air quality legislation. And also have a mechanism for reviewing your legislation to ensure that it's in tandem with the latest scientific development, because knowledge is constantly shifting, and to align your regulation or your legislative framework with the latest scientific knowledge is key. This means that you must define or design your law in such a way that it's flexible to take into account of the latest scientific developments. Thirdly, you also need to take into account the climate policy commitments that you may have made at the global level, which can actually be achieved by shifting to clean energy generation. Now, this can be achieved if you emphasize on more stringent measures on sulfur dioxide and nitrogen dioxide standards, because remember, air quality and climate change are also linked, because the pollutants that are mostly associated with air pollution are the same ones that would contribute to climate change. We also need to empower your citizens so that they can take part in the implementation of air quality laws. So advocacy at whatever level, be it at national or at the city or subnational municipal level, is also key. Do they have this information? Do they have the knowledge to actually support the implementation efforts of the government at any level? Then also the systems of multi-level governance actually provide an effective framework for enforcing ambient air quality standards. Now, depending on your system of government, if air quality management is a function of the national government or a subnational or municipal or county government, then how do these systems speak to each other? Is it an exclusive function of your national government, or is it a shared function between your national government and your subnational government? Because if there is a conflict, then enforcement becomes a challenge, and then you're not able to implement or achieve what you seek to achieve. Then in closing, perhaps for those that may wish to look at this report, we have shared with you a link. Perhaps the same can also be shared on the chat function, and you can get further details on and about this particular assessment. I'll stop there and take it back to Rocky for our next discussions. Thank you so much.
Thank you so much, Alan, for that preview, that sneak peek of the global assessment for air pollution legislation. And just to note, I also put the link over at our chat box, so you can check that out. if you're interested. And really, thank you, Alan, for that comprehensive study covering not just the substantive issues, of substantive law, but also procedural issues and issues including transboundary crime and transboundary air pollution and indoor air pollution. So we're looking forward to read more of that in the global assessment and perhaps discussing more later on how the recommendations can be applied to the Southeast Asian region. So again, thank you very much, Alan. And we now proceed to our next panelist, who will be the first panelist who will focus on the national approaches in countries in Southeast Asia. I'd like to welcome Grita Anindarini, or as we call her, Ninda. Ninda is the program director of the Indonesian Center for Environmental Law, or ICEL. She earned an LLM in energy law from the University of Aberdeen in the UK and a Bachelor of Laws from the University of Indonesia. At ICEL, Ninda contributes to the research and advocacy related to energy and climate change issues, among others. She also conducts legal research on environmental policies and has been involved in several regulation drafting processes related to environment and natural resources, both at the local and national levels. Ninda, happy to have you, and you have the floor.
Yeah, thank you, Rocky. Hi, everyone. It's nice to be here. So, my name is Grita Anindarini, but you can call me Ninda. I'm from Indonesian Center for Environmental Law. So we're basically a non-governmental organization that based in Jakarta, Indonesia, and we focus on environmental law reform. We are very much work on air pollution advocacy as well. Sorry, Colin. Can you just get back from the first slide? Yeah. So, maybe from here, from the overview. Yeah, thank you. Sorry, I may need help to operate my my presentation because my connection is kind of unstable here, but hopefully that's fine. So yeah. For the next 15 minutes, I would like to share with you all about our overview with regard to regulatory framework on air pollution control in Indonesia. What are the legal updates on that? And we also would like to share about an interesting case that just being decided by the court like past weeks ago on Jakarta air pollution citizen lawsuit, and what are the follow-up advocacy that shall be needed after the court decision. And I also would like to emphasize what are the lessons learned that we got for strengthening the advocacy on air pollution control in Indonesia personally. Next, yeah. So yeah, at a glance, we have our umbrella law, law number 32/2009 with regard to environmental protection and management, in which under the law, it acknowledged that air quality standard and emission standard is one of the prevention of environmental pollution and degradation control instruments. And this law basically have many implementing regulations. Next. In which one of them is governmental regulation that's just being enacted like a few months ago, 2021, about implementation of environmental protection and management, in which one of the subsection discusses about the air pollution control. This is the newest regulation that we have, because previously the air pollution control was detailed regulated in the governmental regulation year 1999. So we can see after 22 years, we finally have the newest with some strengthened provision on that. I will describe it later. But the important things is the regulation also acknowledge or introduce about air quality management area, which some of the area which has similarity of natural landscape characteristics, similarity of climatic and meteorological conditions. And the regulation also ask for each area to have air quality management plan. But unfortunately, it is still unclear whether the air quality management area will be based on administrative area, because they divide the area with the national area, province air quality area, interprovincial air quality area. Will it be based on the administrative area, or will it be based on airshed? We just don't know until now. So next. Other than that, we also have several Minister of Environment and Forest Regulations. But for specific this, I would like to emphasize that the air quality management plan shall be drafted not only by the central government, but also by the local government based on the area that they had. Next, that's just an overview about the regulation in Indonesia. We have many regulations on that, but if you would like to discuss about Indonesia regulatory framework, we can discuss it more in the Q&A session. But for the next chapter, I would like to discuss about the air pollution citizen lawsuit in Jakarta that has been decided after 2 years, like past weeks ago. So just some background that since 1997, I think the government actually has been aware that Jakarta has problems in air pollution issues. But until 2019, there is no planned and systematic efforts that have been made to address the air pollution in Jakarta. But the Jakarta's, on the other hand, Jakarta's annual average air quality observation report shows that Jakarta's air quality since 2006 has continued to exceed the annual national ambient quality standard. So therefore, in 2019, around 32 Indonesian citizens decided to file a lawsuit for Jakarta air pollution to the court against 7 stakeholders: President, Minister of Environment and Forestry, Minister of Home Affairs, Minister of Health, Governor of Jakarta, and 2 governors from the province around Jakarta. I will share it because there is some transboundary pollution issues that happened in here. So after 2 years of trial, in 2021, the panel of judges finally passed a decision upon the citizens' lawsuit. And in its decision, the panel of judges grants the plaintiffs' lawsuits in part. The panel of judges granted the most lawsuits to the plaintiffs, unless declaring that this violation also violates the human rights. I will discuss it later. Next. Next, sorry, yeah. So this is just an overview how polluted Jakarta right now. Like in 2017, the daily average of PM 2.5 concentration still in the moderate. But if we if we go on to the 2018, it becoming worse. It become the unhealthy for sensitive groups for most days. But if we look into 2019, next again, it's becoming even worse because next, sorry. Yeah, it becoming even worse because most of the days in that year, we have unhealthy conditions. But on the other hand, we note that Indonesia's national ambient air quality standard is still weak. If we look into the left table, the revision of the government regulation actually makes some improvement. But not for the PM 2.5 because the number is still the same. But if we compare it to the WHO guidelines from 2005 and even from 2021, we can see that the tightening that carried out by the newest regulation in 2021 is still not enough. It's still very far from the WHO ambient air quality standard guidelines. And so, yeah, we're currently working for how to strengthen this standard even more. Next. Yeah, so here is the defendant. I can tell you later about the decision. Next. Next again, yeah. So the district court that acknowledge that the defendants have some violations because they don't make systematic efforts in order to address Jakarta's air pollution issues. So the district court then order the president to strengthen air quality standard that is sufficient to protect human health and the environment according to science and technology, which is we urge them to see the WHO guidelines and to strengthen our current regulations. The district court also asked the Minister of Environment and Forestry to conduct transboundary emission inventory and supervise Governor of Jakarta, Banten, and West Java in conducting the transboundary emission inventory. This is a huge leap, and this is very nice. And for the that's also the request, the order for Home Affairs to supervise the management of Jakarta's air pollution. Next. And the district court also ordered the Minister of Health to conduct the impact study of air pollution that will become a baseline for the governor to compose air quality management plan. This is very good because the district court asked some coordination between institutions that currently lacking of. And the district court also asked the governor of Jakarta to supervise mobile sources and stationary sources emission, to conduct emission inventory and compose air quality management plan. But next. Next. Yeah. But beside all of the decisions that have been made by the court, but unfortunately, the court does not acknowledge, or the court rejected the petition to declare that the defendants have violated human rights because they were negligent in fulfilling the public's rights to good and healthy environment. Because under our constitution, right to good and healthy environment is become one of the types of human rights. So the petition argued that if the defendants violated the rights of to good and healthy environment, they also violated the human rights. But the court did not declare that. The court rejected the petition to declare the violation of human rights. But still, I think this is a huge win for the citizen. Next. Yeah, so what would the follow-up after the court decision? Next. Yeah, so for us, advocating the implementation or execution of this decision as soon as possible is become important as per now. One of the measures that need to be taken is the development of the air quality management plan by the governor of Jakarta. But the governor of Jakarta can't do this alone because next, the governor of Jakarta can do the air quality management plan alone. Next, again. Oh, okay. Beforehand, we would like to emphasize that at least the government needs to follow some of the steps before drafting the air quality management plan. The government needs to conduct air quality inventory. We also urge the government to stipulate the air quality standard in accordance with air quality inventory itself, and also health, environment, social, and economic aspects. We also urge the government to stipulate air quality management area and stipulate the air quality management plan in accordance with air quality management area. So there are many scientific evidence that need to be taken, that need to be considered before the government develop the air quality management plan itself. Next. Yeah, this is why the governor of Jakarta actually could not develop the air quality management plan alone, because of the transboundary pollution issues. If we see the research, actually 14% of coal combustion contribution from outside Jakarta contribute to air pollution in Jakarta. So the coal combustion itself comes from the coal-fired power plants and industries from the province across Jakarta, for example, West Java and Banten. So there are contributions from other provinces to air pollution in Jakarta. So the air quality management plan can be only drafted and only be made by the Jakarta itself, but also need to consider the sources from other provinces, need to work closely with the provinces across Jakarta. And if you see the map in the next slide, next. Yeah, this is like the map, the sources of air flowing into Jakarta during the dry season. We can see how the pollutants come from the other area, the other provinces. This is come from the West Java, and the sector that contributes to this come from the heavy industries, oil and gas refining, power and energy for sure, petrochemicals and plastics. And in the next slide, we can see how the sources of air flowing into Jakarta during the wet season. Yeah, during the wet season, it also come from some of the West Java and some come from Banten. So closely engaged coordination need to be taken during the making of air management plan. Next. Yeah, actually we still see there are several legal barriers in addressing transboundary air pollution issue in Jakarta, in Indonesia in general, because as I mentioned earlier, we don't know whether the establishment of the air quality management area will be based on an airshed or will be based on the administrative area. So we don't know whether the central government will establish Jakarta, West Java, and Banten as one airshed. If they don't identify it as one airshed, we don't know whether they will engage closely to develop the plan. And the government also acknowledged the existence of air quality management plan across provinces. Although the central government still will be responsible to stipulate the transboundary management plan. And we're afraid that it will surmount the bureaucracy and administrative barriers because the legal government and the local government, actually should be one who involved extensively during the process. Next. So this is my last slide. It's about the lesson learned. So what we urge right now is the government needs to stipulate more implementing regulation that specify about the air quality management area and air quality management plan role, because there are still gray area. And we also urge the central government to give the local government more authority to develop air quality management plan, because they have the data. The local government who have the extensive data on that. So it is important to the local government to conduct the air quality management area transboundary with the others. And we also argue that public participation during the development of air quality becomes very important. And lastly, we also argue the government needs to integrate the air quality management plan to other plans, like for example, environment management plan, spatial plan, development plan, how to integrate all of this plan to promote more strengthened air quality management plan becomes important as per now. I think that's all from me, Rocky. So all, if you have any questions or you would like to discuss more, we can discuss on the Q&A session. Thank you.
Thank you very much, Ninda, for that very inspiring presentation. Always happy to hear those kinds of news from all over the region. And that's huge, right? The case that wanted to focus on addressing the government's neglect on the air pollution problem, and the decision itself that declared that there was a violation to a clean and healthy environment. And I'm sure there are a lot of people are interested more about that case. We can talk about that later on, but really thank you for giving us a sneak peek of what happened and the decision that was issued the past few months. So we'll talk more about that later. And just before we start with the last panelist for this session. Thanks for all the participants. I just want to give a shout out to all the participants who have said hi in the chat box from the Philippines, from Indonesia, from Myanmar, Malaysia, Laos, Thailand. So most of Southeast Asia, and even others from outside the region, from Nepal and from Bangladesh. Thank you for joining us, and I'm very, very happy to have you here and participate in this session, and we can talk more in the Q&A session also. So with that, thanks again, Ninda, and we will now proceed with our last panelist for this session. Our last panelist is William Schulte, who we call BJ. BJ is the Mekong Region Policy and Legal Advisor of EarthRights International. And prior to joining EarthRights, he served as Assistant Director and Adjunct Faculty for the US-Asia Partnership for Environmental Law at Vermont Law School, where his work and research focused on environmental governance and strengthening the environmental rule of law in China and in Southeast Asia, specifically in the Mekong region. Before that, BJ also spent 5 years in public interest litigation in New Jersey, where he represented community groups in various legal and administrative proceedings, including air pollution reduction. BJ earned his JD from Rutgers University in Newark and earned an LLM in environmental law from Vermont Law School. Everyone, let's all welcome BJ. BJ?
Okay, let me share my screen. Let's see. Oh, sorry. Sorry, y'all just saw my whole presentation right there. Thank you, Rocky, for the introduction, and to Ariel for organizing this event, and to Alan and Ninda for those very enlightening presentations. As Rocky said, I'm a Mekong Region Policy and Legal Advisor with EarthRights International. We are an international organization, as the name would imply, focused really on providing support to frontline and impacted communities who are advocating for greater recognition of their rights under the law and addressing impacts from large development projects. So before I begin, the topic I was given today was national updates across the Mekong region with regards to air pollution. And of course, that's a very large topic. So I just wanted to say at the outset that I have attempted to provide an overview of the context to try to understand the problem, and then selected a few highlights from a few of the countries in the Mekong region with updates as to measures they've been adopting recently to address air pollution. So I know there will probably be a lot of information that's left out of, but hopefully this will be sufficient to give everyone some food for thought and a fruitful discussion later on. To begin with, I wanted to talk about the kind of main drivers of air pollution in the region, as well as the different types of air pollution, because of course, the solutions that we fashion and that the governments fashion would depend on the problem itself. So as we all know, the region across Southeast Asia and including the Mekong region has been experiencing very rapid economic growth, which has led to increased industrialization, urbanization, increased transport. But then also anyone who lives in northern Thailand, where EarthRights is based, or northern Laos, knows about the seasonal burning, which greatly negatively impacts the air quality across the region. In addition to all this, as a result of the economic growth, energy demand has been increasing across the region by around 6% annually. And on top of that, the region has a high reliance on fossil fuels for energy, mainly oil and coal. And since 2001, we've seen a more than doubling of per capita greenhouse gas emissions in the region. And as Alan pointed out in his presentation, fossil fuel facilities also emit co-pollutants in addition to greenhouse gas emissions. So this is data I gathered from the IQ Air World Air Quality Report, which if anyone is not familiar with it, I would highly encourage you to check it out. They put out the report annually, I believe. But I just pulled some numbers so everyone could sort of understand the situation in the Mekong region. As you can see, none of the countries meet the World Health Organization's recommendation for annual average PM 2.5 levels. And in 2020, only 10% of cities in the Southeast Asia region actually met that target. And the highest levels of PM 2.5 pollution are concentrated seasonally, again, in northern Thailand and the surrounding areas. And the rankings there, I should point out, 1 is the worst, not the best. So these were ranked out of 106 countries. Myanmar was the worst, and then Cambodia came in at 36. So the story being the air pollution problem is getting worse. Smoky season, again, anyone who lives up in northern Thailand knows this very well. It's the main driver of air pollution in rural areas and contributes up to 30% of total PM 2.5 and PM 10 emissions. It disproportionately impacts poor areas because again, it generally occurs in rural areas. And although governments have adopted policies to address this, they are generally poorly enforced. So there's a lot of work there that needs to be done. And I'll talk later. Some countries are taking measures to try to address this more aggressively. In addition, the rapidly increasing industrial air pollution is a growing problem. And one of the things we found is that data and information on industrial air pollution especially is lacking. There's very little, if any, monitoring at the facility level done on a consistent basis in Myanmar, Laos, and Cambodia. This is from the IQ Air study that I cited before, but up to 2/3 of the air quality monitoring in the region is provided by NGOs actually, and not governments. And in Myanmar, Laos, and Cambodia, only NGO data is available for industrial level air pollution. I think it was 2014, 2015, around that time, the World Bank actually worked with Cambodia, Laos, and Myanmar to implement IPPS, which is the Industrial Pollution Projection System. And some interesting findings were that, in terms of industrial pollution, most of the pollution generated is by a small fraction of industrial activities. The bulk of the pollution comes from a few large enterprises, and they tend to be concentrated in certain areas, meaning that a few targeted specific actions could achieve very significant reductions with regards to this industrial pollution. And then transportation also is a huge driver of air pollution, especially in urban areas. I included a table here from a study that was put out earlier this year by the Stockholm Environment Institute on air quality in Thailand. And what color is that? It's like a burgundy, I guess. The dark red color represents road transportation, and you can see that it actually represents the majority of air pollution in the Bangkok area. And Cambodia as well, some experts have estimated that up to 70% of air emissions are transport related. And in October, the Thailand government pollution control department announced new measures to address air pollution from vehicles. So they are giving it attention and attempting to address the problem. When talking about these impacts, it's always important to ask, what's the cost? A lot of, I've heard a lot of people put forth the argument that, we need to, allow development occur. There's a lot of economic development needs in the region, and if we impose stricter environmental regulations, that will impede economic development. But IQ Air, who did the study I referenced before, and Greenpeace Southeast Asia put together this cost of air pollution estimator, which you can find if you just Google it. And I ran it for Chiang Mai, Bangkok, and Rayong, and you can see the numbers there in terms of what they estimated for the annual economic cost of air pollution in those cities, and estimated number of deaths resulting from air pollution. In Vietnam, official data estimates that the country loses 10 to 13 billion US dollars every year due to air pollution related issues. So I know I only have a couple minutes left. I'm going to try to quickly go through a few highlights from a few of the countries. Cambodia has drafted, I listed some of the measures they've adopted in the last decade or so with regards to air pollution. They did recently draft a draft environment and natural resources code, which is designed to clear up, institutional responsibilities, strengthen access to information, and really clarify how air pollution regulation will apply to facilities. The draft is still under review, and there's not really any indication as to when or if it will be adopted. They've also begun installing ambient air quality monitoring stations. As of August 2020, the MOE had installed 41 monitors in 41 locations around the country. And they at least have stated that they release this information periodically on Facebook and on a screen at the outside of the MOE building in Phnom Penh. So they're moving forward in getting that data together. Vietnam recently released a new law on environmental protection, which sets up a new environmental license system, which again is intended to clear up institutional responsibilities. Previously under the law, various ministries at various levels were responsible for regulating various forms of pollution, which essentially meant it was very confusing and difficult to figure out and difficult to enforce. So this new law is intended to address that issue, and hopefully will address air pollution as well. And on the right-hand side, I listed a few directives that the Prime Minister has issued. Most recently in January 2021, directing the Ministry of Natural Resources and Environment and the Ministry of Industry to take certain actions listed there to strengthen air pollution management. And then moving to Thailand, I wanted to end on Thailand because there actually is a very interesting case developing in the administrative court, which I will talk about in a moment. But In February 2019, the Thai government announced an air pollution crisis and directed the PCD, the Pollution Control Department, to take certain measures. And in the PCD developed a plan which was approved by the Prime Minister in October 2019. And then in January 2019, the Ministry of Industry announced new regulations that would require factories to install CEMS, or continuous emission monitoring systems. Up until that point, only about 75 factories in all of Thailand had CEMS installed. So it sort of gives you an idea of, both Alan referred to, problems with regards to access to information. So the fact that only 75 factories had emissions monitoring systems, shows you how difficult the challenge is. But this new regulation will supposedly impact around 600 factories nationwide, and will require them to run these continuous monitoring systems and feed that data directly to the Pollution Control Department, including fines of up to 200,000 baht for non-compliance. So that is an encouraging sign. And then finally, before we talk about the case, there were several draft clean air laws being pushed in Thailand. Two of them, one was developed and presented by the Boomjai Thai Party, and a separate one by the Thai Chamber of Commerce, were both rejected by the Prime Minister earlier this year. The third law was developed by the Thai Clean Air Network, and is still in the process, under the Thai process of gathering signatures. They need to get sufficient signatures in order to present it to the parliament. But this law is very interesting because it's, really meant to address some of the systemic institutional issues that are preventing better enforcement of air pollution regulations in Thailand. It's got a heavy emphasis on access to information, public participation, and access to justice, and advocates for creating a sort of overarching agency with a mandate to direct and drive all of the country's environmental policy. Because in reality, the Pollution Control Department, which I mentioned a few times, is quite a small agency and really has pretty limited authority, and acts more as an advisory agency to other agencies like the Ministry of Industry, which itself has the actual regulatory power over factories. So this draft law is meant to clear up some of that. And then finally, this case I really wanted to mention because it's very interesting. There's been very little publicity or news about it. But basically, in March 2021, a single citizen in Chiang Mai filed a case in the administrative court alleging that the NEB, or the National Environmental Board, violated its duty under Article 59 of the National Environmental Quality Act by failing, there's a typo there, but essentially the plaintiff was arguing that the National Environmental Board violated Article 59 by failing to declare Chiang Mai, Chiang Rai, and Mae Hong Son as pollution control areas. So it's a very interesting case, not only because of the fact that it involves, air pollution, which is a very, pressing issue here in northern Thailand, but also because of the power of the administrative court that this case demonstrates. The plaintiff filed a complaint that was, I think, 1 page or 2 pages long, but the administrative court actually has a lot of authority to conduct additional investigation on its own and call witnesses and that type of thing. So the National Environmental Board argued in its defense that declaring pollution control areas is discretionary, and that they listed a bunch of measures they had already taken to control the air pollution. However, the court disagreed. And after gathering evidence, calling in witnesses, getting statements from like the Chiang Mai provincial governor, local leaders, the health board, many others, the court concluded that the previous actions have not been sufficient or have not been enough to address air pollution, and actually ordered the National Environmental Board to declare the provinces as pollution control areas. The NEB has announced that it will appeal the decision, so this will be a very interesting case to watch, and perhaps something for other in the future in the Mekong region. Laos, I think earlier this year or late last year, issued a new administrative law which seems to give citizens similar power to ask courts to review government actions. So there could be possibility there. So yeah, so that one will be a very interesting case to watch as well. So I'll leave it at that. Again, that was a very quick overview with just some highlights. So happy to answer any questions.
Great, thank you very much, BJ. I know it was a huge task to cover all the Mekong countries, but you did a great job on giving us an overview in around 15 minutes for all these countries. And very happy to note that there are a lot of developments in terms of policy, as well as litigation as well in those countries, and specifically in Thailand. And that's something we could discuss and exchange ideas with the Indonesian case as well later. But yeah, thank you again, BJ, for that presentation. And at this point, I'd like to thank all the panelists, Alan, Ninda, and BJ, for presenting. And I'd like to call them again here for our moderated discussion. If you could just open your cameras. And we are moving on to the exciting part of the webinar, which is the open forum, where we're opening the floor to any questions. And if you have any other questions for the participants, please feel free to type them down in the questions box below. Now, for our first question, this is maybe addressed to all of you because this is stems from Alan's recommendation in his presentation that there needs to be more public participation and there needs to be more access to information. And I'd like to get a sense of firstly from Alan, and then I'll move on to Ninda and BJ on what has been the progress for this, Alan, and in your national assessment, and what are the ways forward for this, and what are the challenges that we still have to hurdle. And then I'll go to Ninda and BJ later for this access to information and public participation challenges on their respective localities and countries, issues in their countries. So yeah, maybe we can start with Alan first with that.
Thank you very much, Rocky. As I indicated in the presentation, there is some impressive work that has been done insofar as public participation is concerned. So we find that in most countries, they have put in place some measures on public participation. And of course, in terms of the laws, we can say that most countries have an avenue for the public or the citizenry to participate in so far as the issue of air quality is concerned. But then the only question that remains is what is the quality of information that this citizen can get? Because ideally, if you do not have the kind of information that is, I think BJ alluded to, that can help a citizen mount a successful challenge to an obligation of government, then again, it's a zero-sum game. So ideally, what needs to happen is to strengthen the monitoring obligation of governments so that they can provide adequate information or adequate data that then the citizenry can use to mount a successful challenge. So I would say, in as much as the framework is good enough in prescribing an avenue for public participation, but then insofar as the adequacy of the data from monitoring is concerned, a number of countries, or most countries, are still not doing well enough, especially the developing countries. So this is something that needs to be strengthened so that the citizenry can participate effectively in ensuring air quality governance.
Right, right. It's something we have to look at, the adequacy of data and the quality of the information. So that's something that a lot of stakeholders can look at as well in helping government strengthen those areas. And Ninda, how about in Indonesia, maybe like specific challenges as to public participation?
Yeah, but beforehand, I would like to emphasize, so in the Jakarta air pollution case, David Boyd, the special rapporteur for the UN, actually gave amicus curiae, and in his amicus, he stated 70 steps in fulfilling the rights to healthy environment in the context of air pollution, and one of the items is he emphasized that making information publicly available, including those related to health issues, is one of the indicator in fulfilling the rights to healthy environment in the context of air pollution. That's a very good amicus, actually. But if we look into the legal perspective, regulatory framework, I mean, and the implementation. So basically, our Environmental Act already mandate that environmental information, for example, like emission information, emission inventory, it shall be open for public. But in Indonesia, in implementation as per now, the data that has been publicly accessed, I think it's only limited to the air quality, the ambient air quality, only that. And we still have a limited air quality monitoring station as well. So this is still become a huge challenge in Indonesia. And with regard to the public participation, I don't think in the governmental regulation, the newest governmental regulation, it is clearly stated that during the drafting of air quality management plan, there's an obligation to make public participation. But I see some of the government's institutions, some of the local governments that already start to make the plan, already have initiatives to engage the public, but still we need more public to be involved, not only specific person, not only specific sectors of public. So how we can identify who are involved, who shall be involved during the process shall be important as well. Yeah.
Thanks, Linda, for highlighting the access to information and public participation needs, especially in Indonesia. How about in BJ, in the Mekong countries, and where ERI is at?
Yeah, it's I mean, that, you know, when I was trying to put together the information for this webinar, you know, the access to information, or the lack of information, is you know, foremost among the most common challenges across the region. But like I said, you know, like there are measures in place that are beginning to try to address that issue. But you know, it's important to remember that in a lot of places, it really is starting from the beginning. I mean, the graphic I put up of the Cambodia monitoring stations, you know, like those are the first ambient air quality monitoring stations that are installed in the country. So, you know, it's important to remember that these things also take time to build. With regards to public participation, that's an interesting one. Like Vietnam, for example, they're under the new law on environmental protection. The ministry is going through a process to develop the implementing regulations, and they're actually quite good about announcing that and like giving NGOs and citizens the ability to participate and provide input. You might ask the NGOs themselves, like, how much is their input actually, considered? But that might be a question for another day. I think on that level, there are encouraging signs. On the project level, however, public participation with regards to environmental reviews at the project level are still a very huge challenge in the region. The public participation processes are usually very bad if they happen at all. So that's something that, I think has a lot to do with capacity on the part of the ministries and enforcement and those kinds of issues.
Right. Thanks, PJ. Yeah, but at least we have the framework, and a lot of countries, I believe, in developing countries are starting the process and moving towards evolving the framework for that. But just to follow through Linda specifically, because there's a question here is on the evidence required. And for that case specifically, what kind of monitoring data did you have or did you have to get? Or is the monitoring quality monitoring data that you had enough to represent the whole city of Jakarta?
Yeah, it's kind of difficult to answer actually, because actually the main data that we need is for sure emission inventory, air quality monitoring inventory. Sorry, can you hear me?
Yes, we can hear you.
Sorry, because you're all, I think there's some, sorry, I have to off the video first, because I think that, so the data emission inventory, the air quality monitoring inventory, and the impact, health impact assessment, environment impact from the pollution. What our challenge was, it's not really easy to get the data because of the lack of information, as I've mentioned before. But if we see the data that we had, actually we use the AQMS, the air quality monitoring system, that it could be helpful if the amount could represent the area itself. For example, in Jakarta, some of the experts say that we need at least 13 of the AQMS to represent all of the data, and some of the experts said we need at least 30. So we try to collect at least 15 and 30 data, or 30 monitoring data. But the challenge was in Indonesia, we only had, in Jakarta, sorry, we only have 6 AQMS. It's very far below the standard to represent all of the data. Maybe Glinda already also make the research on this, and Glinda will be the best person to explain this. But yes, this is the challenge, because we still have very far from the standard, very far of the standard to represent all of the area.
Right. Thanks, Linda. And at this point, I'd like to also welcome Glinda Batan-Baterina to give a short intervention. So just a short intro. Glinda is the Deputy Executive Director of Clean Air Asia, a lawyer with 20 years of experience on clean air, sustainable transport, and was recently named as one of the remarkable women in transport by the Transformative Urban Mobility Initiative last 2020. So Glinda, happy to have you for the reaction and the intervention for this panel.
Thank you very much, Rocky, and thank you to all of our speakers for enlightening us and giving us an update on what's happening in the different countries. It is very encouraging that people are actually now demanding that governments meet their obligations under existing legislation. clean air legislation. So just to react to some of the points that were raised, I have a few points. First is that what was clear in Alan's presentation, that while 66 or so percent of the countries in the world have legislated ambient air quality standards, there was a finding by UNEP that existing institutions within governments are weak and clearly unable to attain the standards because we're still seeing a lot of air pollution. And in the Mekong region, BJ William remarked that there is a clear lack of enforcement of several of these regulations. And what makes air pollution a challenge to tackle are several things. First, the sources of pollution and the actors needed to reduce the emissions there are several of them. And even while we point to, let's say, the local governments as the responsible entity to manage sources of pollution, as what Ninda mentioned, there are sources outside of the territorial jurisdiction of a particular local government that may be not within the reach of a specific local government's power. And so what does this mean from a legal point of view? It means that new legal constructs are needed, such as the concept of an airshed or an air quality management area. That was part of the decision of the Indonesia court. And this requires entities like local governments having to work with nearby local governments that have an impact on a specific city's air pollution. What does this also mean? Different sectors contribute to air pollution. So it's not just industry, you have motor vehicles, you even have households that do open burning of municipal solid waste, contributing to the quality of the air. And this means many of these sources are also within the ambit or the authority of different agencies. You have the Ministry of Transport, you have the Ministry of Urban Development, you have the Ministry of Mineral Resources, Energy and Mineral Resources. And this new construct of requiring an air quality action plan is the means of having to get all of these sectors work towards a common goal and ensuring that this action plan is also aligned with development plans. One thing that we must ensure is that the plan, in order to be realized, needs to be funded, and it cannot be a standalone air quality action plan that is not linked to the economic development plans of the city or of the country. Otherwise, it will be one of those unfunded plans that remain good on paper but don't ever attain their objectives. Now, you might ask, has this ever worked? Has this system, this kind of constructs, legal constructs like an airshed or an air quality management area, an air quality action plan, have they actually worked? And the answer is yes. If you go back to the previous webinar, Ariel presented the case of Beijing, Tianjin, and Hebei. What was the reasons for the success of reducing air pollution in this region? First, they had time-bound 5-year clean air plans with clear air quality goals, quantitative goals. There were specific percentage of reduction in specific pollutants to be attained within a specific period. And second, there was clear accountability of the local mayors, that they were the ones responsible for getting this done. Now, people might say, they always say that, well, how do you generate the same accountability in a different governance context? Because not every country is similar to China. So now I propose two two ways to do this. And first is you generate the accountability just as what the Indonesia or Indonesian civil society partners have done by having a court specifically state that specific actions need to be done by government defendants. That means it generates accountability because the court can now require reporting by those defendants on progress made in implementing the court decision. That's one. Another is we have in the Philippines called, we have a Clean Air Act in the Philippines. And because the act was passed by Congress, there was a body that was created in both houses of Congress called the Joint Congressional Oversight Committee. And this committee exists, its function is indicated in the law, in the Clean Air Act. And therefore, this means that the agencies that have been given the mandate to clean the air need to report or need to answer to this oversight body in Congress on whether they have been implementing the law. They have been successful in implementing the law. Now, you might say, okay, have we actually done this in a Southeast Asian context? Well, we started the seeds. Clean Air Asia worked in Bogor City. We helped develop a participatory and science-based clean air action plan that was based on evidence and which involved the public participation. But mind you, public participation, increasing public participation or strengthening the participation of civil society requires capacitating civil society. You know, the issues that we are talking about are very technical. And so we need to capacitate civil society groups, academia, NGOs in order to allow them to engage in the discussion. I'll hand this over back to you, Rocky.
Thank you, Glenda. That was a wealth of information. Thank you so much for sharing us. And the concept of this airshed, this air quality management area, is very important. And maybe I could link it to some of the questions also that require or consider the necessity of strong institutions from government. So you've mentioned like the court's role and the oversight committee's role in Congress. But there's a question here, very interesting, from Malaysia, because she's asking if there have been initiatives to use the national human rights bodies in actually taking legal actions for this, especially now that the right to breathe healthy air is considered a fundamental human right. No, so I'd like to ask the panelists if you know any initiatives on how this has been framed as a human rights issue and went through the human rights institutions in their respective countries.
Yeah, maybe I can start, Rocky.
Sure.
Looking back to the Jakarta case, actually the National Human Rights Commission in Indonesia also testified as one of the experts, and they also give the recommendations to the judge that the right to clean air is one of the right to get the good and healthy environment, and that's because it's also being part of the human rights, the fulfillment of the human rights. It's pretty much easy in Indonesia to linkage because in our constitution, it's already clearly stated that right to good and healthy environment is one of the human rights pillars. And the National Human Rights Commission also already stated that. But unfortunately, as I mentioned before in my presentation, the court failed to link the decision that they made to the human rights consideration. They did not really declare that this is a human rights violation, even though in their consideration they acknowledge that there is a human rights violation on that, but they don't really specify it in their decision. So yeah, I think the challenge now is how we can really make a judge aware that there is a strong linkage between human rights pillar and right to good and healthy environment. I think that's one of advocacy on that, because in the National Human Rights Commission in Indonesia already clearly state it clearly in the court. Yeah.
Right. Thanks, Linda. And any others from? I know from the Mekong countries, I don't think they have used this avenue, but in the Philippines, Linda just shared the petition by Greenpeace. We have also used the National Human Rights Institution, the Commission on Human Rights here, as for the petition for climate change litigation. So that's being tapped as an avenue. So it would be good to look at how things play out also in other jurisdictions and their national human rights bodies. So great. Thanks, Linda. And another question for all of the panelists, because there has been an observation that many of the things that are happening have focused on the role of governments and regulations, but how, on the flip side, how can we challenge the industry, or how can we make the industry change? So maybe not in the context of regulation itself, or maybe beyond that. Are there any other initiatives or instruments that we can use to spur change in the industry aside from regulations, or within regulations itself, what more can we do? So who would like to take a stab?
I don't know if it might be still within the regulations. I hope that's okay, but
no, it's okay. Go ahead.
But actually, Glinda, the information you just provided kind of reminded me of this, or made me think of it. And I think China actually offers a pretty instructive example or lesson for the region, in that, in 2015, China amended its environmental protection law to allow environmental public interest litigation for the first time. And this was a culmination of years of efforts by NGOs. And in the late 2000s and early 2010s, China started seeing a lot of very large protest events and social unrest because of the heightening pollution levels. And the government realized, like, on the one hand, we need to give people a legitimate venue to raise their concerns, and we need to give them, we need to enlist their support, essentially, to enforce these new laws. So I think that's something, it has not been recognized in the Mekong region, but something that I think, governments and NGOs should consider advocating is sort of essentially enlisting citizens to support the government in enforcement of environmental laws.
Thank you, BJ. Any thoughts from other panelists? Yep.
Well, yes, Brooke, if we could just chip in, not necessarily from the findings of our global assessment, I think there's still room for some of these voluntary standards that industries could come up with. But the only challenge is this, that in most cases, if it's left at the whims of industry, or if you leave it voluntary, especially in the developing South, then you do not have a level playing field, in the sense that some industries might choose to observe the voluntary standards, but then others might not. So there's always a danger or a risk in coming up with these voluntary standards. But having said that, it's also a good starting point to engage industry, because insofar as you engage industry in developing these standards, then compliance and enforcement at the relevant stage becomes easier, because they've been involved in the formulation of the standards, and therefore they understand the challenges that will be faced when it comes to compliance. So yes, there's a positive aspect insofar as voluntary standards for industries is concerned, but then you need to watch out that you don't develop an uneven playing field for the relevant industries concerned.
Yes, yeah. Thanks, Alan. So the engagement with industry, you highlighted how important it is to complement everything that's with the regulation and like the voluntary standards as well. So I know don't have a lot of time, but there's just one question. There's a question that keeps popping up, and it's also highlighted in the presentations in Indonesia and the Mekong, which is transboundary air pollution. So there have been questions on like what are the suggestions or how can we tackle this? Maybe may it be through legal actions. What what evidence do we need to collect, and what are the remedies for the transboundary air pollution problem? So maybe the panelists can share from their study, from the assessment, or from their experience in their respective jurisdictions.
I don't know whether I could chip in at this point.
Go ahead, Alan.
And I hope it's not discouraging news at all. But in our study, we also examined the existence of some transboundary air quality management mechanisms at the various regions. And whereas we found the existence of these regional agreements or mechanisms, for Asia, it was a bit patchy. And the only transboundary mechanism we found was the 2002 agreement on haze, the ASEAN 2002 agreement. But then unfortunately, even that one only focuses on land and forest fires. So ideally then, what are you left with? Do you then come up with an amendment to that so that you expand the scope of the haze agreement to include air pollution, or specifically also mention air pollution? That would be one option. Alternatively, would you then, the ASEAN countries, consider establishing a regional mechanism that then addresses air pollution? In my view, this would be the best option if expanding the scope of the haze agreement is not possible. But again, you need a regional mechanism so that you can harmonize the various standards within the region. Otherwise, if you're left with different measures or thresholds in different countries, then it becomes difficult to enforce or apply. Thanks.
Right. Thanks, Alan. And maybe to tag on to that, BJ, yes, go ahead.
Yeah, just quickly, it doesn't have to do specifically with air pollution, but for any lawyers on the call or legal nerds or whatever, there was an interesting case earlier this year in Thailand where the Thai court accepted for the first time a class action lawsuit brought by plaintiffs from outside the country. So these were Cambodian farmers who were forcibly evicted from their homes by a Thai sugar company in Cambodia. So the court earlier this year actually accepted them as a class and is allowing them to move forward with the lawsuit based entirely on actions of the company in Cambodia. But because it's a Thai company, the court is exercising jurisdiction. So something like that could, serve as precedent in the future for transboundary cases.
Oh, yeah, indeed. That's very interesting, BJ, and something to look forward to also the developments in litigation that encompasses like transboundary considerations, right? And yes, with Alan saying the prospects for regional mechanisms, maybe Glinda can share more like what have been the initiatives on regional initiatives for air pollution and addressing the issue.
Yes, thank you. I just posted here. US EPA has been working with the Chinese government in developing, in really trying to see if regional air quality management, which is a similar concept as an airshed, which goes beyond the limits of a single local government unit or local government. So one working example is this cooperation between the Hong Kong Special Administrative Region and the nearest province within mainland China, which is Shenzhen. And they have for several years been working together, actually sharing air quality monitoring stations to monitor the transboundary movement of air pollution between their jurisdictions. And they have also come up with certain measures to reduce the transboundary impact. And if I remember correctly, I'm not quite certain whether this is in the 2035 Clean Air Plan of Hong Kong or in the previous one, but there are, this is all documented, what is the goal and what are the specific measures. So similarly, in China, the Pearl River Delta region was also they also tried to create a regional air quality management group similar to the BTH or the Beijing Tianjin Hebei. The feedback is that it takes a lot of work and a lot of commitment to actually make the different local governments come together and work with each other. In fact, for the BTH example, it needed a lot of supervision from the central government to actually have them all work together. So yeah, maybe what we can do is, since we talk of transboundary sources, but actually one solution is, okay, each local government focuses on the sources within its jurisdiction and reduces those as low as possible, and then we wouldn't have to deal with transboundary pollution, right? Because it's so difficult to it's so difficult to well, it's quite easy to say, look, I point to my neighbor for the air pollution that's happening in my city, right? That's so easy to say, just point to somebody else. But the real responsibility is you would eliminate transboundary air pollution if each local government unit would just take care of the pollution sources in your own jurisdiction. I think for now, and we can demand accountability there because it's so clear. It's within your jurisdiction, you have responsibility for reducing it.
Right. Thanks. And that goes all the way to our topic for our theme for this session, which is national interventions, right, to really solve this national issues and also transboundary issues. So, yep, I think we should end there for the Q&A session. It's been a very an engaging crowd with us this afternoon. And maybe as a last step for this webinar, I can ask all the panelists for maybe 1 or 2 lines, last words on this topic for our participants. So just 1 or 2 lines, and then we can wrap this session up. So is there anyone who would like to go first?
I'll take a stab.
Go ahead.
I don't know. I started out my career as a lawyer litigating citizen suits in the US. I'm a big proponent of empowering citizens and communities to contribute to efforts to strengthen. So I would, there's a number of problems we had identified: lack of information, lack of public participation, institutional authority. But I would really love to see governments allow citizens to support them to enforce these laws.
Thanks, Vijay. Appreciate that very much. And yeah, Glinda.
Yes, thank you. I've never been much of a litigant. I'm a litigation lawyer. So I started off trying it out, but it just didn't suit me. So what I would say, so now actually, I think we need 2 strategies. We need the pressure coming from from public litigation suits and other civil society activist movements. But alongside that, we also need civil society groups helping governments strengthen their capacity to deliver. It is not an easy task. And as you can see, even the more developed countries have taken decades and are still struggling with new air pollution sources up to now. So we need these two-pronged strategy. of putting pressure to just show urgency to secure accountability, and on the other hand, helping government meet its responsibility.
Thanks. Thank you, Glinda. Ninda?
Yeah, sorry, my connection is really bad. But yeah, I would like to emphasize that to fulfill the right to clean, right to good and healthy environment, right to clean air is one of the important substance, and it's not the substance. It's not we do not only talk about substantive issues, but we also talk about the procedural issues, how the fulfillment of right to participation, the fulfillment of right to information is really important to support the fulfillment of right to clean air, right to health, a good and healthy environment. And I think it should become the main mind in every stakeholder, is that, for example, the fulfillment of public participation has close relation to the fulfillment of clean air, for example, because I think this is the like connection that still in there. So yeah, I think how we can really note in our mind that all of these substantive rights and procedural rights is really connected to support the fulfillment of clean air for all. Thank you, Rocky.
Thank you, Ninda. And lastly, Alan.
Well, I would say that air quality management or governance must and should always be a collaborative effort. It cannot be left to the government, it cannot be left to industry, it cannot be left to the citizenry, or perhaps even the municipal government for that matter. So again, you must empower the citizen to be able to keep the government in check, or the relevant authority in check. Then the government itself must really put in place the relevant framework that can ensure that we achieve the right to a clean and healthy environment, or clean air for that matter. And the industry must also play its role in ensuring that the level of emissions is kept at a bare minimum. So all must play their part. There's no question about it. Thank you.
Right. Thank you very much, Alan. And thank you for all the panelists for those closing statements. Apologies that we went a bit over time, but it was such an engaging conversation. And at this point, I'd like to close the program, and I'd like to thank the panel, Alan, DJ, Ninda, Glinda, for all your insights and your expertise and your time, and for today's webinar. And we hope that through all these efforts at the national level being scaled up across the region, we may be able to uphold the right to breathe healthy air as one of our fundamental human rights now. So again, thank you to all the panelists. Thank you for all the participants who joined in and shared their time and interest in joining us for this panel. Again, this has been Rocky Guzman from Ariel. Thanks again for tuning in this afternoon, and we hope to see you in our next event. Goodbye.
Bye-bye. Thank you.
Bye. Thank you.
Thanks, everyone.
Thanks all.
Bye. Thanks.
Bye-bye.